Good afternoon, everybody. First, I want to thank my graphic design, Mr. Eduardo Duran, for such a wonderful design. I want to put it back up so you guys can see the work of Mr. Duran. 1 second. I'm going to remove myself so you guys can see this work. So shout out to Mr. Duran for that. Just shout out to him. And he put in my purple like I like it. So he did a excellent job. Shout out to him. Um, so we are going to talk about the 27th, which was the verdict day. I was hoping my readers would come on in here, but they're standing me up. Hold on a second. Let me just put it in here for a minute. Just a second. I'm going to send this out to them. But prior to that, I want to play something for you guys. Just 1 second while I do all of this. I'm going to play this part of this interview with one of the attorneys who supposedly went to see Robert. I'm not playing the whole thing. I'm just going to play the ending part of this, okay? All right.
John. So, he didn't have the resources to fight this case the way that he needed to.
So, as I understand, you actually met R. Kelly in prison before his trial began. Explain to us why you were there. And secondly, what do you believe is next, given that there's another federal trial for him coming up in Chicago?
Well, I met with him in 2019 in the Chicago NBC, and that's the federal holdings area. And this was before I don't recall if it was exactly before the Brooklyn case came out. Actually, the Brooklyn case, I met with him there in Chicago, and he was there to potentially screen me as an attorney. He didn't have the resources to hire me or my firm, and I knew he was meeting with a bunch of people. When I first met with him, he was locked down like an animal. I mean, I can tell you, I've been in a number of prisons. I've been in prisons actually in other countries to meet with people here who are being extradited back to the United States. I've never seen anybody who's treated like the animal that R. Kelly was in the Chicago NBC. He was put in the shoe. It's the first time I've had to meet somebody who was in handcuffs. We were within a stone's throw away. I mean, from an interstate serial killer and who looked like Hannibal Lecter. It was something else. I had personally never experienced it. I've been practicing at the time, hitting my 20th year of practice. It was extraordinary. He didn't need to be in that kind of situation for what he was charged with, being this close to a serial killer or alleged serial killer, let me be clear. But that's how he was treated. And it took him months to get out of that solitary and into general population. And I met with him a second time after that, and he had been broken. He wasn't the same person. I actually questioned his mental fitness. And I think that's something that needed to be looked into. Ultimately, he didn't have the resources to hire me, but I'm concerned about him as a person. I can't really tell you what he did, but what I can tell you is my impressions of him. And he wasn't all there.
Vinny Varghese, we appreciate you joining us to talk about the R. Kelly case. Obviously, it's not over yet, but we'll continue.
Y'all heard what he just said, right?
Wow.
That solidified what I read earlier. That solidified. I gave you documentation on it, and then now somebody who was an actual eyewitness of what they saw. Did you guys hear what he just said?
Dang, that at one point, that the point they're bringing, he looked like Hannibal Lecter. And that's from that movie, Silence of the Lambs.
Yeah, but they had him handcuffed. He said he went to see him as an attorney. He's already behind bars. It wasn't like he could run out. But they had him handcuffed, and they said they had broken him.
Well, the Hannibal Lecter part, you got to realize that's that mask over his face. You know what I'm saying?
No, they didn't put a mask over his face.
Huh?
They didn't put a mask over his face. They just had
I was trying to understand the part where they said that when they brought in, he looked like Hannibal Lecter. Hannibal Lecter was handcuffed. Handcuffed.
No, they're saying basically Hannibal Lecter was a serial killer. So they were
Right.
actually treating him like as if he was a serial killer.
Oh, okay. I
I
thought
can
I
I
thought
can
I was
replay
getting
that
ready to
part
say.
again for you.
Okay, got
I
you.
can replay that part. Just 1 second.
Well, I met with him in 2019 in the Chicago NBC, and that's the federal holdings area. And this was before I don't recall if it was exactly before the Brooklyn case came out, or actually the Brooklyn case I'm sorry. I met with him there in Chicago, and he was there to potentially screen me as an attorney. He didn't have the resources to hire me or my firm, and I knew he was meeting with a bunch of people. When I first met with him, he was locked down like an animal. I mean, I can tell you, I've been in a number of prisons. I've been in prisons actually in other countries to meet with people here who are being extradited back to the United States. I've never seen anybody who's treated like the animal that R. Kelly was in the Chicago NBC. He was put in the shoe. It's the first time had to meet somebody who was in handcuffs. We were within a stone's throw away. I mean, from an interstate serial killer and who looked like Hannibal Lecter. It was something else. I had personally never experienced it. I've been practicing at the time, hitting my 20th year of practice. It was extraordinary. He didn't need to be in that kind of situation for what he was charged with, being this close to a serial killer or alleged serial killer, let me be clear. But, that's how he was treated. And it took him months to get out of that solitary and into general population. And I met with him a second time after that, and he had been broken. He wasn't the same person. I actually questioned his mental fitness. And I think that's something that needed to be looked into. Ultimately, he didn't have the resources to hire me, but I was concerned about him as a person. I can't really tell you what we discussed, but what I can tell you is my impressions of him. And he wasn't all there.
Vinu Varghese, we appreciate you joining us to talk about the.
Okay. So did you hear what he said now?
hmm Oh, that was a guy that sounded like a woman. Okay, but that was really cold. And the part that because everything is basically done off or done with money, because you kept hearing him said, I heard him say twice that he didn't have the resources to hire me. Well,
Yeah.
sometimes in cases like this, you should be able to just do it pro bono. I mean, at least just say take it on, because especially if you're seeing the injustice that is happening to our brother, you should be able to just take this, say, you know what, I'm going to do this for you pro bono. And let's just say sometime down the line, that if you're able to, recover, your assets or anything like that, then that you just don't forget this. But for right now, I'm going to take this on right here, because he was giving us an insight of what he saw and the mistreatment of our brother. And then he just kept referring, well, because he just didn't have the resources to take me on, the resources from him. I'm like, that's the part that just, that part right there is like, okay, you've seen this, but when you say you didn't have the resources, basically he didn't have the money. And, in other words, he just said he couldn't afford me to really get him off, or get him off, or get stop whatever was
But I'm
happening
going to show
to
you,
him.
speaking of that, I'm going to show you a news article. Someone sent it out to me. Shout out to the person that sent this to me. But let me show you what happened with this. Look at this. Did y'all read this?
Which one are you
You
referring
see it?
to?
Are you looking at it?
Hold on. I'll be in the chat room and then I'll come back here. London police takes no further action against Prince Andrew after review. Yeah, that was the part that I seen on that Jeffrey Epstein's documentary. And this man here, oh, I'm not gonna
Read
say
it.
anything else.
Read
I'm
it. Read
trying.
it.
I see you. Hold on. Let me turn my phone to the side so I can be able to see it. Okay, Virginia Roberts filed a lawsuit against Prince Andrew in New York back in August, accusing him of sexual abuse, claims he denied. Okay, slow down.
London Metropolitan
London
Police.
Metropolitan Police will take no further action against Prince Andrew following an investigation into sexual abuse lawsuit filed by Virginia Goldfree in New York earlier this year. Uh, Goldfree's lawsuit claims that Andrew forced her to have sex with him. What is that? Three separate times between 1999 and 2000. Look at them years, y'all. Accusation Queen Elizabeth's son, now 61, has consistently denied. In a statement shared with People on August 9th, when the lawsuit was first filed, Goldfree, 38, said in part, I am holding Prince Andrew accountable for what he did to me. The powerful and rich are not exempt from being held responsible for their action. I hope that other victims will see this will see that it is possible to not live in silence and fear, but reclaim one's life by speaking out and demanding justice. After London's authorities, oh look, after the London authorities looked into the documents and evidence, I cannot reveal. I think that is your logo is hiding it. Related to the U.S. court case, they decided not to move forward. Wouldn't you know? That's power. As a matter of procedure, MPS Metropolitan Police Service officers reviewed a document released in August 2021 as part of the U.S. civil action. The review has concluded and we're taking no further action, they said in a Monday statement, according to Reuters and CNN. The Metropolitan Police Service continues to liaison with with other law enforcement agencies who led the investigation into the matters related to Jeffrey Epstein. Wait, we went up too far. Come down some.
A
A
source
source.
close to
Okay, yeah. A source close to Andrew tells People it comes as no surprise that the Met Police have confirmed that, having reviewed the sexual assault claims against the Duke for a third time, they are taking no further actions despite pressures from the media and claims of new evidence that the Met have concluded that the claims are not sufficient to warrant any further investigation. The Duke has always vigorously maintained his innocence and continues to do so. In 2019, in a 2019 interview addressing the prince's relationship with the disgraced financier Epstein, Goldfree allegations against him, Andrew told the BBC, I have no recollection of ever meeting this lady. None whatsoever. It just never happened. Following backlash from the interview, Andrew announced he would be stepping back from public duties. Isn't that interesting? Yeah, that's him. And she actually has the picture. I've seen the documentary. I think it's the.
Okay, go ahead.
Hold on. Let me pull it up.
It's more.
Oh, I'm sorry. Oh, Goldfree alleges that she was forced to have sex with the royal three. Yeah, she would. Yeah, okay. She was forced to have sex with the royal three times between 1999 and 2000 in London, New York, on a private Caribbean island owned by Epstein, who died in August 2019 in prison. Speaking specifically about Goldfree's claim that he danced with her at a London exclusive Tramp nightclub before allegedly having sex in a mansion in the Belgaria neighborhood. The Duke said, no, that couldn't have happened because the date that's being suggested, I was at home with with the children. Andrew, who is the father of Princess Beatrice and Princess Eugene, added, taking Beatrice to a Pizza Express in the working in Woking for a party as I woke sort of 4 or 5 in the afternoon. And then because the Duchess was away, we have a simple rule in the family that when one is away, the other one is there. I was on terminal leave at the time from the Royal Navy, so therefore I was home.
Was at home.
Was at home. So I got a text on saying was at home when the BBC Newsnight anchor Emily Metlis raised the issue of the photo showing the royal with his arms around Godfrey's. Yes, I saw that one. Around Godfrey's waist, though to have been taken inside the London's home of Giselle Maxwell on March 10th, 2001, when Godfrey was 17. The royal claimed he had no recollection of the encounter. I have absolutely no memory of the photograph ever being taken, Andrew told Mathis. Before questioning the authenticity of the picture itself, because he's wearing his travel clothes as opposed to his regular suit and tie, he suggested that his left hand had been photoshopped onto Godfrey's side in the image. I don't remember that photo ever being taken, he said at the time. I don't remember going upstairs in the house because the photograph was taken upstairs, and I'm not entirely convinced that is what I would describe as me in that picture, but we can't be certain as to whether or not my hand on her, whatever it is, left side. In her August 9th statement, Godfrey said her attorneys filed the suit against Andrew under the Child Victims Act, saying, I did not come to the decision lightly. As a mother and a wife, my family comes first, and I know that this action will subject me to further attacks by Prince Andrew and his surrogates. And I knew if I did not pursue this action, I would be letting them and the victims everywhere down.
Okay.
Yeah, let me see if I can bring that up. Not on here, on my television. I watched that documentary, and I'm telling you what this man did, and wherever he's at, we know he's no longer living. So I don't know if I want to say his name because I don't want to violate anything. But this man and that picture was of the brother Andrew, and he was standing there with her, and that lady had no reason to lie. And what they said is that
Well,
they would go out and
let
recruit.
me tell you something.
Mm-hmm.
Like I said, there's two different
I'm gonna
laws.
tell you. Yes, it
It's
is.
two different laws. I don't care what nobody says. Two different
You're right.
laws.
You are right. You are right. Yeah. Well, that family now. Come on. You're talking about the queen's. What is that? Her son or a grandson or nephew? Mm-mm.
Her son.
Please. Her son.
Mhm.
Hmm. Money, power. Trust me. When you have money and you have power, you can make things go away that actually happen. When you really don't have it, then they get alleged things that you've done and bring things and embellish things and deny you your rights and do not do what they're supposed to do because you don't have the money to fight them. Hint.
It comes back to what you were saying about the attorney kept mentioning the money in regard to Robert.
Mm-hmm. Mm-hmm. Exactly. Exactly. But he just could not. He just didn't have the resources to uh, to get me rather. And I was like, you see that this man and what is happening to Robert is wrong and a violation of his rights, his human rights. And yet and still, what you bring up twice that I heard is that he couldn't afford you. He couldn't afford you. Oh God, boy, I tell you. Mm, yeah. How do y'all feel about that, Jeff? FFERY. Hold on. Trying to get that documentary by him. Space.
Okay, I'm getting ready. Did you get the transcript?
Did you send it to me?
If I'm asking for it, it means I sent
No,
it.
I'm saying I didn't. Hold on. Let me
You
check
didn't
my
answer the
email.
question. How you
No,
gonna
I'm
answer the
saying that
question with
because
a question?
I haven't received. I didn't know if it was one that we've already had or if it's something else that I need to be
You
checking
answered
for.
a question with a question. I said, "Did you get the transcript?" He said, "Did you send
Okay.
it to me?"
Well, see there, little smarty. You ought to know that if you didn't send it, I didn't
Obviously,
get
if I'm
it.
asking for it, that means I
That's
sent
what
it.
I'm trying to say. No, I didn't get. I
Thank
didn't
you. Thank you.
receive it. God, don't start with me.
Lord have mercy.
Oh God, right here.
Hold on, let me resend it. Hold on, let me resend it.
Mm-hmm. Yeah, resend it. Delete, delete, delete. EF. Let me see. Let me see. Make sure that I'm. Hold on one sec. Oh God, I'll be having to switch between my readers and my distance.
Go, oh man.
Hold on. Chrome. Oh dang, it's in the wrong one. Okay, maybe Gmail. No, I haven't gotten. I'm still waiting to. God, no, it's not there. Okay, YouTube. Can't go there. um, Instagram. Mm,
All right.
Okay, there we go.
Okay, I need someone to play. Okay, Rhoda, you still in here? Because I need Rhoda. I need Rhoda.
ST.
Thank you, one May Day. Appreciate you. Thank you. Thank you so much for the
Yeah,
cash app. I mean, yeah, super chat.
next.
Super chat. Thank you. I appreciate it. Rhoda, are you coming in or are you still working? Should I wait till later? Because I can bring out some other material stuff if your guys are not ready. But let me send this off to you. I just need to
Movies.
just 1 second.
Okay. See, that's what it's called. Hold on. DIRTY. I think it's called Dirty Money. Space. MONEY. Next. Let's see. Dirty Money, Dirty Money, Dirty Money. Dirty Money.
Oh, you off today? Okay, let me put the link in. I'm sorry. I forgot today was a holiday. Everybody's home. Okay, my apologies. My apologies. I did not know it was I forgot it's a holiday. Every day is the same day for me. So except the weekend. So I truly apologize. I did not know that half of you guys are home. No wonder why I was getting messages like, "Oh, are we reading today? Are we reading?" My bad. I don't know what day it is. It's always the same day for me. Sorry, my bad.
H space. I'm gonna get that documentary
What you
for
looking
you.
for?
The one where the young lady. Oh, you just got to see the documentary as a whole. It will space the story. It will, and just how they were covering this up. I mean, the federal government came in assisting, covering up what Jeffrey Epstein was doing. They came in and assisted. Wow. Money and power, JEFFRY. That's the difference. Jeffrey, space, E. I think I have to go in there and look at my living room on my TV that's on there.
But thank you guys. For those who are here who has been in this chat. You guys are awesome.
Hold on, I'll be right back.
You guys are awesome. So what I'm getting ready to do is I am going to let's see. Here's what we're gonna do for the winner. For those who find a good one for you guys. Rhoda, click the link for you to come in, please. All right, I got a good question. Which is the reading? Which reading is this? This is going to be for the last day when the judge gave her when the jury came back asking for questions. This is the jury day, the verdict day. That one, that reading is the one that we're gonna be doing. Blessed and restored. Yeah, that's the one. I don't think none of you guys got it because someone. Rhoda, you coming in? Or are you busy? Trying to get some readers in here. I need, let's see. Just bear with me a second. There she go. Rhoda, I'm going to send it to you right now. I know you don't have this one. Yes, I did the closing for Canic already, Alicia. I did it already. But I started from the beginning again with all the transcript. We haven't gotten to that one yet, but I wanted to read this last one right here. So.
I found it.
Okay, hold on a second. I was answering a question for Alicia. So we are going to get back to it again. But I did have the closing remarks, and if you go back to my old videos, you should see it there. That's a good question. Okay, for the $100 winner, tell me what day did I do that reading, and who played Canic? What day did I do that reading and who played Kanik? First person that respond will get the $100. How about that? Thank you for that question, Alicia. You just helped me out. You just helped me out. Hey, Lanford, what day did I do the reading and who played Kanik? That's both two parts. What day did I do that reading and who played Kanik? What day did I do the reading and who played Kanik? And you will win $100. And thank you for that answer, for that question, because she helped me out with trying to come up with a trivia. This is about putting black entertainers notice. Zach, Zach.
One May Day, $50. Thank you, sweetheart.
Huh?
Wow, $50
What happened?
from One May Day.
She
You
did
see it
that.
right there?
You're late, dude.
Okay, I'm just coming in and reading. I'm sorry.
I'm just messing with him. If I keep messing with you, somebody's gonna say, "Oh, you so rude." So I'm gonna stop playing with you.
It's all right, yeah. I'm used to it now.
They looking for the answer. They searching for the answer. They can get
Boy,
the
they are, aren't they?
$100. It
This is
seems like
taking them a
nobody's
while.
saying anything.
It's taking them a while to come up
Nobody's
with it.
saying anything.
Ooh, the chat is filling up. 103 in here and 46 likes. Come on now.
105.
5 down.
So what day was that played and who played Kanik? What day was that played and who played Kanik? And you're going to get, if you get the answer on that one, you're going to get $100. It's going to be sent to your Cash App. Hey, Tia.
$100.
$100.
Hi, Tia.
Y'all not.
Then they're guessing, talking about Daddy Lola.
You got to put both parts. You got to tell the date that it was done.
The date it was read, that he read. This for you wasn't paying attention. The question was, what was it, Sylvia? Someone said they wasn't. No, remember, I was away getting the information.
Here's the question. Okay. Thanks to Alicia. Alicia came in and asked, was we reading Kanik's closing remarks? And I said, no. So I said, that's a very good question. Who played Kanik in the closing remarks reading? And what day was it done?
And you must subscribe to Mr. Fofofo as well. Must be a subscriber to Mr. Fofofo. The winner must be subscribed to both. The winner must be subscribed to Mr. Fofofo and to this page.
Oh, y'all way off. I said closing remark. Fifi won it. Wow, Fifi, did you win already? We gotta find out if Fifi won already. Fifi, did you win?
Let me see. I'll look at that name and tell you. I think that name sounds familiar.
Your name sound familiar.
Let me see who won in here, Fifi.
Fifi, did you win? Did you
Yeah, yeah, she won. I hate to
gotta
snitch
come up
on
with
you,
another
baby.
question now. Sorry,
Yeah, you
Fifi.
got to come up with
Done
another
before.
question.
Gotta come up with another question because I can't
Hmm
give it.
She said October 5th, and Mr. Terry was canning.
Oh,
And for y'all,
Fifi,
Mr. Terry is Sultry's
Fifi, you
Fifi.
messed up. You won for 4. You can't
You
win.
won. She said, I won the $10. Yeah, but you won, sweetheart. You
You
know,
won before.
our contest
Sorry.
is if you won, you have to
If you
wait 30
win, you can't
days.
win anymore for 30 days.
And
I'm
remember, Sylvia, that the winner must be a subscriber to Mr. 444 and this page. So
yeah,
y'all
sorry
remember that.
guys. Okay, we're gonna do another one. We're gonna come up with
Mod, if you can put 444's YouTube page on here so that at least they'll be able to go there and subscribe. Because they have to be a subscriber to his page and this page. Oh, Fifi, I'm sorry. Yeah, you did win. That's why we say, you usually
me
kind of
too.
have to
That's why I
wait.
gotta do another question. Oh, don't be sad, Fifi. But we gave you the rules. Whoever
You
won
know,
within the past 30
yeah,
last
30
days.
days.
I said 60 days. 60
30,
days. I
60.
said 60.
Okay. Well, if they want little like that, that's not fair, I don't think. If
If
they
they
want
still
like only
they
$10, but I
still
guess
won,
I
they
said
should
30.
never got in it.
Okay. Yeah, if
Because
you've
remember
already won, please don't answer the question. I
no,
mean,
what's
please
her name?
don't
Remember
answer.
how who was that the other day? Was it Mimi? She threw it back. She
No,
said
that
no.
that wasn't Mimi. That was was that? Yeah, that was Mimi.
Mimi threw it back. She says
Yeah,
no.
Mimi threw her little $5 back.
She said nope. I'm not. She says I don't want to win it. So Mimi's still in the round running.
Yeah, yeah, Latrice, we know you won. That's why you on. That's why you waiting.
Latrice won too
Yeah,
many times.
yeah,
Latrice
yeah.
tricked us.
Before we came up with this, so
Latrice
so
tricked us. Okay.
so mods, if you can put Mr. 444's
If you have won,
YouTube channel.
listen to this. If you have won with you won anything, even if it's $5, if you got the money from us, you are disqualified for even being part of this one here. Okay.
Yeah, you can't be a part of the.
I can't give it to the next person because the next person got it because Fifi put it out there. So that's not fair.
Hmm
So Fifi put the answer and it took a while for somebody else to put it up. So we can't do that. So what I'm gonna do, I'm gonna come up with another question for the $100. Sorry, Fifi. All right.
Zach Jim said, "Can or should prior slave owners be charged the same way with the RICO Act?"
That's a very good question.
Yeah, prior slave owners, I think they're probably dead, so that means that it probably would have to pass, I mean, go down to the descendants, which isn't fair because they may not have been born at that time that that happened. So that's a good question, but the prior slave owners, or if there are any now that, actually are having slaves or what they call it cheap labor now, having stuff done for cheap labor. So
Okay, we're gonna
depends
come up
on.
with another question.
She's going to come up with another question.
Another two-parter question, and it's gonna
Thank you, Miss T. London. She put Mr. Fofo smiles info. So if you haven't subscribed to his page already, please go there and smile. I mean, go there and smile. Go there and subscribe.
and every question has to do with something having to do with Robert. So okay.
Hmm
All right, here's the next question.
hmm
It's gonna be a two-parter question. Okay.
Yeah, two-parter question. Mm.
Okay. This is a
Take your
tough.
time. It ain't a rush to get it. Just take your time as you think about it.
So where's Rhoda's been having a hard time getting in. I was trying to get her in so you guys can start reading. And I need a mail. If somebody don't mind coming in to read, I need a male because you got scholar, you got Canic, and you got the judge that's going to be talking on the 27th.
Guess what I'm doing, Sylvia?
What you doing?
I'm going on a 72-hour fast, nothing but water.
Oh, look at you.
She's sick.
What?
Listen, I never did it before, but I want to. I
I've
feel
done it.
that I.
That's good. That's
Mm-hmm. I'm gonna try it, see how it works.
okay. Well, Kyle, I'll pray for strength for you. I pray God's strength.
Hmm.
I pray God's strength while you fasting.
Oh, thank you. That'll be easy. I'll be doing that and that green tea that I showed you about. Hmm. A Chinese green tea. Shopping.
All right, Terry.
Hmm.
Um, did
Hmm.
you get your thing? I did send it to you. Did you check your email? I sent it to you twice.
Yes, hold on. Let me check again because I haven't.
I sent it to you too many times already.
Hold on, woman. I'm gonna take your screenshot and show you that I haven't got. Okay, there's something. No, the last thing I got from. Hold on. Oh, it just came at 1:35. What
No,
time
I
is it?
just resend it again. That's my second.
No,
That's the
I'm
second.
gonna take your screenshot and show you. The
Send it. Just
last thing I got from you was at 8:19 this morning. No, I just got it. Just.
Lisa wants you to sing happy birthday to her.
I don't think y'all want me to sing no more.
No, I just don't want you to sing Robert's songs, but you can
That's
sing.
all right. I did that on purpose so y'all won't ask me to sing.
No, Lisa wants you to sing for her birthday.
Okay, I got it. I got it right. Let's see. Hold on. Doo-doo. Phone. Okay, we're starting at the first page on this 4723. Not now, but I'm just making sure.
First one,
Mm,
yes.
mhm.
Where's Randa? She's supposed to be doing something for me. Hold on, y'all.
Where Henny Hen at? You sleep? Where you at, sweetie?
She
Where's
texted
Geddes?
me
Because
earlier.
I see a lot of Geddes up in this one. Where's Candy Cane at? Where you at, Candy? You in here?
Hey,
Yes.
did you see my email?
Another one?
That's
Hold on. Are you talking to me or you talking to somebody else?
I'm on the phone.
Okay.
Yes, darling. But I got.
Look at that. Here's a Christmas check from my credit union. Here's a Christmas check for you. Holiday check for you for $2,000. Please bring it in and redeem it. Nope. I'm good. Maybe trying to, I don't know though, because that could become revolving. I don't know. I have to think about that one. Mm-hmm. So, Sylvia, I went to somebody's page and I lit some smoke. You seen the email? I mean, the email? And I was getting likes. I know she can't stand that. She's probably going to see me as another enemy now. But the people, it's funny, the people following her on the page is giving me likes. I think the last I looked, I had 14. And then the next 8 people on her page that says some only had like 4 or 5 likes on their questions or their comments. Told her she didn't want to mess with me. Fig, you saw my comment. You liked it. Thank you, baby. I figured it was us over there. Thank you. Yeah, she don't want to mess with me. She don't want to mess with us. Yeah, she is struggling. She only had like I think 14 people, 14 people that came inside there. Yeah, she's struggling. Mm, 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 mm. What you doing, Sil? Mm, 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 mm. Half of them were her own troll account. Oh, really? Yeah, she kept. You see the one where she tried to think she had Robert's brother on there or something, trying to debunk the other females that claim they're his sisters. You know, like he was struggling to breathe. Mm. Getting my saying the same question. When I get okay. Mm-hmm. Of course. Yes, of course. Fo. What's- So how's everybody's Monday so far? We're just quiet on here. I can't just have y'all quiet. While you looking for something, Sylvia, and she play a little of your boy, our buddy, our brother. I don't say no
On this
boy.
channel.
Oh, you can't. Oh, okay. Oh, okay. I'm learning the difference between. Okay, I got you.
All
Got
right.
you. I'm learning. Got you.
Sorry, guys. I'm trying to get my people in place because we don't have enough folks up here to read the transcript.
Is there any volunteers that would like to read the transcript? Are there any volunteers? Is there? Are there any volunteers that like to read the transcripts?
The transcript.
Transcript. Oh. Candy Kane, I see you in it. Is Candy reading? I see Candy's in here.
Annie, can you do the what's the name for me?
Miss London, I know you're mod, but are you able?
Are you willing and able? Okay, I'm gonna send it to y'all now. We want.
She says she can.
You said you can't?
She can.
Okay.
Candy Kane says she can.
All right.
Teacher Bunch. Good. That's so to speak. 55. How about your Monday? Oh, Monday was relaxing. Thank you for asking me, Deidre. It was relaxing, no work. And I was up early this morning with Seal. We were on here doing our thing.
All right.
So it's been relaxing.
Rhoda and Candy, look at your email.
Miss T says she don't mind.
Miss T also said she'll do it.
Yeah, she said, I'm awake today, LMAO.
Okay. All right, Miss T. I'm gonna send it to you right now. Just bear with me.
Vera says she would love to read, but she's not computer savvy. No, it's not. It's just that once you receive the script, you download, it's going to come on a PDF and you just open and start reading. Mm-hmm. And so you digging me, Miss Fast said she would, but her background noise is only for other channels. Gotcha. That's pretty smart too. Mm-hmm. That's right, Miss London. Let them know.
Oh my God, I can't remember her. Miss London, what your email starts with? Don't give me the whole thing, just what it start with, because I can't remember. I got a brain fart right now.
Mm-hmm.
Just where to start with. Just the
She
first
has a CRS right now.
first
What
letter.
does it start with? What's
It's
the
always
first
something
letter, Miss London?
because I know Candy's working.
TANNIA.
I got it.
She got it. She got it now. hmm How many in the chat know what CRS means? CRS. Let me see. See how savvy you are. CRS.
All right, there we go.
CRS.
Woo. I had a brain fart. My phone is acting up.
There's a CRS.
Send link to my email. I asked him too much today, man. I got
Say
one.
what?
I got one who always say he don't have something, and then I have others who just like, could you send it to my
That's
phone?
right, Mike. Let's see that some more. And Taylor said credit repair specialist. That's a good one, but that's not what Sylvia has. She has CRS.
Yeah, they go. Thank you, Ed Waller. Yeah, this is the
Customer
guy
relations
my,
specialist.
who has been
Latrice.
working on my logo. This is Ed Waldo Duran, Mr. Duran.
Just I
He
guess,
is
and I'm
the
getting ready to let
bomb,
y'all know.
diggity bomb. If you guys
Yeah.
need some sort of graphic design, he is the man. He's very patient with me, pain in the butt, Sylvia.
Look in the chat. That's what CRS stands for. That's what she's suffering from right now.
What am I suffering from?
It's in the chat.
What's that?
CRS. CRS?
Common sense syndrome?
No, what I said. hmm Yeah, it could, but when Sylvia was having a brain fart as she came, that's why I came up with it. I mean, I came up with it, but was saying that right there. Make sure y'all subscribe to Mr. 444's.
Hey, Candy.
Hi, can you hear me? Okay.
Hi, Candy.
Hello, Terry.
How are you doing, my love? That's my candy kind.
I'm well. How are you?
Thank you. I'm good. Thanks for asking.
Good. I'm glad.
hmm
Okay.
All right, guys, are we ready?
Wait, let me see. Are we supposed to have a?
Well.
Yeah.
Hi, Rhoda.
Rhoda, you sound like you're breaking up. Rhoda, you really sound like oh my God. Oh. Oh.
Is she playing?
She sound like she playing harmonica or something.
No, she sound like Kelly's about that song "I'm Bossy" about to come on. Dun, 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 I'm bossy.
You must be giggly today, sir.
See what are you
You
doing?
sound like he's sleepy. He just started talking. You.
Whatever.
Okay, could someone please get Miss Rhoda some help? Oh, she's gone. I hear water running. Hold on, y'all.
What's up, chat? Terry, check your IG. I did. I did. I did. I responded. Check my
All
response.
right, my good people are here now. Thank you guys. Thank you for your time. Thank you for your presence. Let's get started now. It makes me want to start the whole live again, but I don't think so. What do you
No, we good.
Because
Why, unless it's going to come down on your minutes.
just let's figure out what the marker is, so we'll just start from that marker.
Sorry, Sylvia, who would you like me to be?
Let me see. Let me see. I got the two wonderful accents up here.
Yes.
England,
Yes, we are.
yeah. Cheer for
It's in the
England.
house.
Londoners as well.
What would you like me to be?
Londoners.
England
Play?
is in the house, people.
What would you like me to play?
Okay, I can unplug this so it won't
I
say
love it.
overheated. Mm-hmm.
Y'all, he's talking to himself again, y'all.
I know.
No, I don't need to
Can y'all hear
unplug
me?
my phone.
Sorry.
Then-
Now we can.
Yes, we can.
Now. Oh, here we go.
Who is it?
I can't even get to the screen where the mute button is. I'm like, oh my God. Wait a minute, let me try this. Hold on.
I think her Wi-Fi called COVID.
Mm. She has a COVID Wi-Fi.
Oh, Jesus.
Oh God.
Jesus. Bless you.
Wi-Fi COVID lady. All right, guys, we're almost ready. We're so sorry, but we have all this technical difficulty today. But please forgive us. We will get it together. And I know somebody's going to say some complaint. I'm going to get the complaints on the email or the. So what I'm going to do, I'm going to put the starter on it once we get Miss Rhoda in. And I'll put a pin to tell them where it starts. All right. Okay, guys, and we're about to. You ready, ladies and gents?
Can you hear me?
Yes, we can hear you.
Yes, Rhoda.
Okay. Oh my Lord. Oof. Okay, yeah, I'm ready.
Places, please. Places.
Rolling action. Roll it.
Who am I going to be, Sylvia?
Oh, I'm sorry.
Okay.
Forgot. Hold on. Yeah, I need your position. Sorry.
It's all right.
My bad.
It's all right.
Okay, we have Canic, which is, of course, Sir Mr. Voice. And then we have the judge, of course. And we have Getty. And we have Calvin. So who wants to be Calvin? Who wants to be the court? Okay, we already got court.
Whatever. We don't mind, do we?
You could be Getty. And then
Okay.
Miss
Getty.
T. London will be Calvin. Sounds good, guys?
Yeah.
Yeah, that's
All right,
fine.
here we go.
And who am I again?
You,
Oh,
you're
my
somebody.
dear.
You're
I
somebody.
know, because every time I'm Canic and then the other Canic shows up and then the original Canic shows up and then I'm demoted.
They're not demoted.
So
We're back to you. All right. All rise.
Hi, everybody can have a seat. Could I see the lawyers at the side for just a minute with the court reporter? All right, just to be clear, so everybody that's been tested, including me, is negative.
wait.
Can it?
We're on 4723, right?
Yeah.
Right.
You're on number 4.
Okay, because
line
I didn't
4.
see line
Line 4.
Okay.
That was on 22.
Number 4.
Yeah, I'm like, I didn't see on the side, but okay. All right, just to be clear, so everybody's testing negative. Canic, right.
So I'm not saying anything to the jury about it. There's no reason to. And that'll be the end of that, I think. Anybody else to say about that?
No, Your Honor.
Can it?
No, Your Honor.
Okay. So we have a note that we'll give to you, and then anything else?
No.
No.
One other thing for me, though, have you guys shown that or let the media listen to
Gettys?
I think they're doing that today, but it's available, so they just have to set it up.
Okay, it has to get done. Okay.
It's ready. It's been ready to go.
But don't you have to tell them?
I think that they have.
Oh, okay.
But
Okay. All right. We received a note from the jurors, and it reads as follows, and you'll get a copy of it. We, the jury, need clarification of Illinois Criminal Code, Section 510-1. It is stated two. I know it's two different ways. A difference between and or is making a clear decision difficult. And then the second thing they won't is testimony from Nicholas Williams and Tom Arnold. I think what they're saying, and I can't remember if I gave an instruction on this, is whenever the government does an indictments, they use and instead of or. And I think all I have to do is instruct them that that's the way the government phrasing the indictment. What is the instructions? I've given it before, I just don't remember it.
I believe it's literally when the term and is used in the indictment. It should be interpreted as or.
Okay. Do you have anything you want to say about that, Mr. Scholar or Mr. Canick?
We're just consulting right now, Your Honor.
Okay.
Your Honor, we're just a mind that and means and.
Well, I know both of you were prosecutors for a long time, and that when you indicted cases, you put and in the indictment. I think everybody who is a prosecutor did that.
That's because I thought it meant and, Your Honor.
Oh, well, I'm sure in those cases that instructions was given, and it's a standard instruction here. So I'll give the instruction that so when the term and is used in the indictment, it should be substituted with or.
I just want to look at the indictment with respect to this particular charge.
And while you're looking for that, I take it that the testimony of those two witnesses are available to go back.
We'll have to quickly check it, but it should be available quickly.
And I guess we have to give the defense a chance to take a look at it. I think for the future, if you've got transcripts ready to go that are redacted, might not be a bad idea to just proactively have the defense take a look at it.
Can I make a statement right there? Did y'all see that?
Mm-hmm.
Exactly.
Mm-hmm.
Amazing.
Mm-hmm.
I thought they were supposed to see the whole thing.
Yeah, isn't that
Why
interesting?
is it redacted? Okay.
That's crazy.
The only thing I can see them redacting is the sidebar. I can understand that because they didn't hear it in court. But all the other stuff, like the testimony, why the testimony has to be redacted?
Exactly.
When they sat there and listened to the testimony in court, and they gave all the exhibit in the testimony to the jurors. So kind of weird. Okay.
I think with respect to this appears to pertain to racketeering Act 3 and is used in a couple of different places. So perhaps we could just advise them that the indictment read that the defendant did knowingly and intentionally, secretly confine as individuals to wit Jane Doe number 3 against her will and induced Jane Doe 3 by deceit and enticement to Jane from one place to another, with intent secretly to confine her against her will. In that particular count, the "and" before induce should mean or, right?
Or induced?
This "and" before the word induced should be interpreted as or.
Okay. All right. I mean, I understand your position before, Mr. Canick, but aside from that,
Aside from that, we're fine.
all right. I don't think there's any reason to tell them why that's done, except I might make a general statement about, I think they're going to wonder why that's the case. I know I would.
Your Honor, Mr. Scholar would like to weigh in. Mr. Scholar,
Judge.
Judge.
We got
Oh,
some
I'm sorry.
already.
Oh, I'm
Hold
sorry.
on.
I'm sorry.
Hold on.
I thought that
Judge.
was a continuance. Go ahead.
Right.
Go ahead.
Judge, just the way that we're looking at it, it's two different theories and two different elements. The secretly confined and then all dealt all by deceit or enticement induces another to go from one place to another with intent secretly to confine.
Right. That's what they said.
Yes, but you're going to instruct that or is or.
Yes. Right? I think.
I was just trying to be clear, Judge.
But you agree that, well, I'm not going to, I know you don't want to agree, but for purposes, that's the way the indictments are drafted.
Oh, that's fine, Judge.
Okay. What do you think?
Sorry, just one moment. We want to look at.
Sure.
Your Honour, we were just looking for an example of the actual charge. I don't think we have any. I think we all agree that particular "and" means or, but we'll continue to look.
I think I'm also looking at some other ones that we've given. And while one of you is doing that, can somebody else get those transcripts and defense can start looking at it? I'm just trying to make the best use of our time here. I have a status conference that's going to take 2 seconds. Is this going to take a while? Can you email your friends and get them?
Yes, Your Honour.
All right.
Who's Miss Shahada?
Just to be clear, we have emailed there's a paralegal.
I know.
Do you want us to clear out so the other?
No, I want to get this instruction done and then we'll send the transcripts back. So I feel like we're on the brink of having the answer here.
Let me get this straight. So you're going to bring them in. You're just sending the instructions back?
No, I'll bring the jury in because I think I have to explain that to them. It shouldn't take very long.
Your Honor, we found this is from the charge of Judge Valentino and in the United States versus, I'm not going to chop the man name, D, and it reads as follows.
Slowly.
One or more counts of the indictment may cause a defendant of violating the same statute in more than one way. In other words, the indictment may allege that the statute in question was violated by various acts which are in the indictment joined by the conjunctive, and while the statute and the elements of the offense are stated in the disjunctive use of the word or. In these circumstances, it is sufficient for a finding of guilt if the evidence established beyond a reasonable doubt the violation of the statute and by any one of the act charged.
All right. Anyway, you can print that out for me.
Yes.
I might make it a little more plain English. That's nothing against Judge Valentini, Vitaliano. I just want to make sure everybody who.
Valtaliano, that's what she said.
Okay, Vitaliano. I just want to make sure everybody can understand it. Actually, you know, I wonder if I could just copy it and put it in a document here with using my mad computer skills. Let's see. Look at that. If I print, will it print to you?
I would have to see what you say, what yours says.
You're printing something already. Okay, great. All right, this is just what I plan to give them. So one or more count of the indictment may accuse the defendant of violating the same statute in more than one way. In other words, the indictment may allege that the statute in question was violated by various acts, And the indictment uses the word and, while the statute uses the word or. In these instances, it is sufficient for a finding of guilt if the evidence established beyond a reasonable doubt the violation of the statute by any one of the acts charged. I wish there was a more normal way to read that. Is there a way to do it in a less passive? The indictment may allege, sorry about that. Okay, maybe this instead. One or more counts of the indictment may accuse the defendant of violating this statute in more than one way. In order, the indictment may allege that the defendant violated the statute by various acts, which are in the indictment, joined by the word and while the statute and the elements of the offense are stated using the word or. In these instances, it is enough. Does that sound better?
Yes.
Aside from your other objection about giving the instruction at all, is that the language okay with the defense?
Judge, I don't want to.
I can't hear you.
Judge, I would like to ask the court to take a look at the United States versus Hayward. It's 19-1054. It was just decided by the Second Circuit. And in that case, the court had to decide whether using a disjunctive actually gave the jury an adequate chance to decide unanimous what the basis of the verdict was. So they decided there was no clear way of determining whether the jury decided from the column A or column B.
But that's a different issue. That doesn't talk about the jury instruction. I actually think I know the case you're talking about. I think that might have to do with the verdict sheet because I don't think it was broken down in the verdict sheet. I don't think that addresses this issue, which, as I say, I don't understand any case to have overruled this issue, which is indictments are phrased in the conjunctive and the statutes are phrased in the disjunctive. I think that has to do more with determining when the jury reached a verdict, which thick they found. Oh, Lord, I don't think that's an issue in this count, is it?
I think the way that the statute reads, I think it would be, because the way the statute reads is that they have to find either confined somebody against their will,
Right.
or enticed or induced another to go from one place to another. But the way the instructions is reading, it allows them to find him guilty if he did one or either of those things.
I don't think this is one of those instances where they have to be unanimous on one theory, is it?
It could be. You know, these two, because they're divided, I think this could be an instance, I don't know for sure, but I think this could be an instance where there would have to be unanimous or of one of the other.
I didn't instruct them that. You didn't request it. Neither side requested it.
Wow.
And I'm not saying that it is. We would have to take more time. I think to answer the note, though, that Your Honour's proposal is sufficient.
How is the verdict sheet? Let me look for it. I definitely gave that instruction on some of the counts, but I was not asked to give that instruction on this particular account. This is Racketeering Act 4. It just says proved or not proved, and then which of the acts, sexual activity. This is, but that's not the question. The question they have to decide unanimously is whether she was unable to give knowing consent or whether there was a controlled substance.
That's correct. For Racketeering Act 4, you did instruct that they needed to be unanimous on which theory?
I did not give that instruction with respect to the statute. And as I said, I don't think anybody asked me to do that. And I don't think it's appropriate. I'm not positive. Don't you think we should find that out, though, before we bring them in?
Wow.
Faye, can you pull up that case? I think the basic rule is still that the ands are read as ors. And I think the issue of whether the jury has to be unanimous on that is something separate.
I agree.
Its Court of Appeals docket is 19-1054, 1054 Crim.
When was it decided?
It was decided on June 28th, 2021.
You can go on the Court of Appeals website. What is the docket number 19? What?
1054.
Hayward?
Yes, this was the change in the law from the Supreme Court, the Supreme Court's decision in the United States against Davis under 924C.
Yes, Judge, because I have more. So in the United States versus Lowry, Lowery.
Right.
It is 64 Fed Appendix 879. It's a Fourth Circuit case, but it was denied by the Supreme Court. And the premise of that case was that the effective charging of the crime as a one single count as a conjunctive created a single count for a judgment. And it was basically a general verdict of guilty. There was no way of determining, which area the jury found.
But what's the statute?
The statute?
What's the particular statute they're talking about? Usually these are talking about federal statutes. Here we're talking about an Illinois statute. And I'm not sure the same logic applies when we're talking about a state criminal statute. I don't know the answer. Like I say, when I give you my instructions in advance, I like to have these things ironed out and nobody raced it, although you had the instructions for some time. So I think this is an unusual time to be making this decision. But it's, I guess, better late than never. But I really would like the answer to that question. I mean, there are cases that talk about federal statutes and the extent to which a separate verdict has to be reached or the jury has to be unanimous. But we're talking about a state statute, And I think that analysis might be different. Maybe it isn't. I don't know.
Mm.
But here's what I'm going to suggest. I'm going to do my status conference. I'm going to ask the parties to sort this out quickly, please. And then let me know what your decision is. The issue that's before us has to do with the government, the way the government phrases its language in the indictment. That rule is clear, that the ors are read as ands. What's not as clear, I'm sorry, the ands are read as ors. But you've raised something separate, which again would have been interesting to know before I charge the jury. So I'm going to give you a little bit of time to sort that out. But the answer to this, to the jury's question, is pretty straightforward. So we can do two things. I can give them that instruction, the and versus or, because that's what they want to know, and then send them that testimony back, or we can wait.
I think, Your Honour, it makes sense to wait a few minutes to sort this out so that we can give them the instruction all together.
All right, let's take the defendant back. We'll be in recess with this case. I'm going to do this status conference, and I hope within 15 minutes we can sort it out, okay? Defendant? All right, I'm just reviewing the case that Mr. Scholar submitted. First of all, do you all agree on something?
I don't think so.
Again, this isn't really dealing with the precise issue of the and or, which we resolved, but it's the question of whether I think the court held that there was double punishment. But I still don't know how it was charged to the jury because the statute reads in the disjunctive. And so the question is, does the jury have to be unanimous on? I don't know if they gave them a verdict sheet or were there separate counts of the indictment.
Judge, I can't tell from the case. I would state that the language, it says that they had made a distinction in the case that the sent the court, the people versus Siguenza. They made a distinction that the elements were charged separately, and they made a special distinction about the fact that they were charged as separate, basically separate crimes, separate counts.
First of all, let me ask one question. Can we send the transcript back?
Mr. Farinella just gave me two things to look at, which I'm doing right now, and then we'll be able to print and send it back.
All right. I like to give them something. All right. So you're saying that since they've charged them separate, that reflects how the Court of Illinois would handle it, correct?
Yes. The way they've indicated in the case, there was a special distinction that they were charged separately. But I would like to also argue under another case is the count. Sorry, is the court could give me 1 second.
Overruled, sure.
And Your Honour, we have a quick case as well when Your Honour is ready.
While you're looking for it, why don't I hear the government's case?
There is a case called IOB, AYOUBI, People versus IOB, at 163 NE 3D 224, and in that case,
What year?
to 2020. And in that case, the defendant was charged with one particular aspect of kidnapping. I think it was confinement. And the court says, while the jury was not asked to consider asportation, we find that the evidence was sufficient to establish both forms of kidnapping. And then it cites another case for the proposition, and this is the parenthetical stating that Illinois recognizes a single murder offense which may be committed in a variety of ways. That the method of the murder need not be specified in the indictment, and that no reversible error occurred where the defendant was charged under two methods, and the evidence supported the court's decision to submit an instruction on a third method. And I believe the import of that is that, similar to the murder statute, that court viewed the three different methods to violate kidnap as a means and not as an element. And so there, one of the means, asportation, was not included in the indictment, and the court found no error. Obviously, we have different scenario here, but I think that under the court's ruling, the different forms of kidnapping are a means and not an element, and therefore there's no requirement that the jury be unanimous as to the particular means for which the statute was violated.
Wow.
Damn.
Mr. Scolo, what's your other case?
Judge, I would like to argue that the case Brito is more applicable to the circumstances. After looking at Ayobi, I would argue that it's not necessarily applicable to this set of circumstances. The other case that I was looking at it's a footnote in United States versus Howard. It's 742F, 3rd 1334. It's page 1349 at footnote 3.
Right.
And basically it states, even though it's an 11th circuit case, it just states that with this racketeering charge, state offense, not a state offense, but where racketeering offense hinges on a predicate offense, and in this case, it's a state offense, that to give the jury a general verdict, it would not be appropriate. And so I would argue that even if the court finds that it's a state offense at issue, because it's part of it's what the racketeering charge hinges on, it doesn't really matter. It should still be the same way you would look at a federal charge, would be the way you look at this charge.
Well, I think that's talking about something slightly different. I think the question is, when you're charging a state offense, I think you give the jury the instruction on the state law. And it seems to me, the way the state interprets it, that is what we should be talking about. I'm not aware of a case that says the opposite. And it also doesn't make, maybe I'm wrong here, but I don't think it's the province of the federal court to say, well, the state court interprets it this way, but we're going to interpret it a separate way. I don't think that's appropriate when the predicate act is a violation of state law. I mean, that's why we give the instructions on the state law. So I think what I'm trying to get from the cases is the extent to which, if you were in a state court, that if the defendant accused in state court would be charged with two separate accounts. And here, I think we're talking about confined against her will or induced her by deceit. Those are two separate things. And I don't think those would be separately charged.
Judge, can I have a second look at the pattern jury charge, like I submitted for bribery?
The Illinois pattern jury charge. Yeah, that's a good idea. If they have it, that'll be good.
Yes, we are looking at the pattern jury instructions, and I don't think...
Well, he said it first.
And I don't think they're helpful, unfortunately.
Not finished.
Mm-hmm.
She disappeared? She said,
Sorry?
"Hey,
Oh,
you're not finished."
but do you want us to send them to you?
Oh, yes, sure.
I also just think that isn't the issue in Seguinza, Brito, whether the exportation is incidental to the kidnapping? I mean, that's kind of, at least in New York State Court, is usually called to whether it merges or whether you can give them separate sentences.
Yes, Judge, that's the issue. But I just thought that since they specifically indicated that there was a distinction between they were charged separately and they've made a special mention of the fact that it was charged separately.
But not the same issue here.
Not the same, but it's just that they made a distinction about that.
Because I think that's a different part of the statute. So and that's why I mean in Brito, in Seguinza, Brito, it was also an evidentiary challenge. I don't think it was a challenge to the method of the verdict.
No, it was not, Judge.
So he was charged with different counts of aggravated kidnapping. He was charged with asportation, confinement, and criminal sexual. Wait, is that right? No, kidnapping, asportation, kidnapping, confinement, and this is really...
Your Honor, I may have a solution.
Okay.
There's a section of the Illinois pattern jury charge on kidnapping which indicates issues in kidnapping, and it may be something that the court would be interested in looking at to determine whether the way it's instructed or proposed in the pattern jury instruction, I think would be more appropriate in this case.
All right. If someone will print that out for me, I would love to see it. What about that testimony? Done?
Being printed as we speak.
All right, let me unmute myself. Sorry. I'm going to be everybody in here. Being printed as we speak. Okay.
Okay.
Judge, I just sent it via email.
To Miss Green?
To everyone.
Oh, okay.
Your Honour, I would just note that in the Seguinza Brito case, just in the language, the court does appear to treat the three different violations described in the kidnapping statute as just different methods of committing kidnapping, which appear to be more akin to different means by which an individual can violate that statute, and not separate elements that would require a unanimity finding. So I think by virtue of the language used there, it's additional support for the prospect that there's no unanimity instruction required.
So here's the pattern jury instruction that is Mr. Scholar gave. To sustain the charge of kidnapping, the state must prove either he must prove that the defendant acted knowingly and that the defendant secretly confined the victim against her will. Then there's a second way of proving it, that the defendant by force or threat of imminent force carried the victim from one place to another, and that when he did so, he intended secretly to confine the victim against her will. And then the third way is that the defendant, by deceit or enticement, induced the person to go from one place to another place. And that when he did so, he intended secretly to confine her against her will.
And then the bottom, it says that if...
Yeah, I see. If you find, depending on which theory is submitted, that you don't, that the state hasn't proven it, then you should find the defendant not guilty.
That any one of those propositions has not been proved beyond a reasonable doubt, you should find the defendant not guilty.
I don't know that we're going to solve this right now. I'm going to propose that discretion is probably the better part of valor here, and to avoid some kind of an issue in the event there were a conviction, it probably makes sense to charge them that they have to be unanimous on which thing it is. I'm just not hearing a clear.
Your Honor.
I would be very interested in seeing a case in Illinois that charges the defendant with, that doesn't charge them separately.
Your Honor, I believe the AOB case is, I mean, it's not on all fours with our situation here. But in the AOB case, the court specifically says that the confinement and aspiratation are just a means through which somebody can commit the crime of kidnapping, and finds that there was no violation for not including one of the means in the indictment. And they specifically, for that proposition, they say it's akin to the murder statute, which may be committed in a variety of ways. So I do think that there's an Illinois case that supports that these two different methods of kidnapping are just means or methods and are not separate violations that require a jury to be unanimous.
I'm just getting the case. Is that the testimony? Great. Donna, maybe we can have that taken back.
Thank you.
Thank you.
You know, I actually don't think any of these things apply to this particular language. The language is not whether he used force or deceit. The language is that person knowingly and intentionally, secretly confined the person who testified as Sonia against her will or induced her by deceit to go from one place to another secretly. I mean, it's really the same thing. It's that he did both of those things. It's not an either or proposition, I don't think.
No, Your Honor, I believe that it is, that there are two different.
What I meant is there's not two different elements.
Agree with you.
I don't think that there's a separate element, because in order to have kidnapping, you have to have somebody confined against the person's will intentionally. And this one is simply saying the method that he used. It's not. If it were force and deceit, then you would be right. But it's not. It's he secretly confined, and this is how he did it. And those are not two separate elements.
I would disagree.
But I mean, it's a different thing. In fact, the instructions make it clear. The pattern jury instructions make it clear that the defendant is charged here with one of those methods. He's not been charged with the other ones. Okay? I think that's the answer. You can think about it for a moment if you want, but I don't think, and I think that's why, frankly, nobody raised this when I sent out the jury instruction, because it's not the same thing. It is the case in the other racketeering acts that are in the indictment, but it's not the case here. I don't think. I mean, I'm just going to take a look at that other case. Yeah, I think this is another case where the concern of the court is whether the kidnapping is incidental to which comes up all the time in kidnapping cases, whether it's incidental to whatever if it's robbery or something like that. In IOB is really talking about the same thing. And again, in the beginning of that section of the opinion, the court talks about three forms of kidnapping: knowingly, secret, when he or she knowingly and secretly confines another person against her will by force. So it's by force of imminent threat, carries another from one place to another with intent to secretly confine that person against his or her will, or by deceit and enticement, induces another person to go from one place to another with the same intent. So those are the two different ways. I think that's right. Are there three different ways? I guess there are three forms.
I think there are three forms set forth in a statute.
I think that's right.
Yes, Judge.
But aren't you only? Oh, I see.
We charged two of the three.
Right. He was indicted based on asportation with the intent to confine, and the judge only gave the instruction on actual confinement, not the second part that's alleged in the indictment. So that judge only gave the charge on the first. Is that correct?
I believe, yes.
And then the appellate claim was
that there was sufficient evidence of the asportation component.
Even though the jury wasn't asked to consider it?
Right.
But what I would direct your Honor's attention to, oh, that's still you, I'm sorry.
Geddes, after right.
But what I would direct your Honor's attention to is right under sufficiency of the evidence where it cites People versus Maxwell.
That says that it may be considered in a variety of ways, that the method of the murder doesn't have to be specified in the indictment.
And I think by a similar token here, the method of the confinement, the method of the kidnapping, whether it's secret confinement, whether it's by deceit, enticing someone to go from one place to another with the intent, that those are just different means by which someone can violate the kidnapping statute and not separate elements.
So the indictment charged both the asportation and the secretly confines?
That's correct.
And the judge only charged on...
Oh, I'm sorry. I think their indictment only charged the secret confinement. If you're talking about IOB, so I don't believe that the posture of IOB is akin to what we have here. I just think that it stands for the proposition that those three different methods set forth in the kidnapping statute are just methods and means.
But then on, I guess, the top of the page, 238 or 113, it says this distinction informs our consideration on both kidnapping related contentions.
Wait, where are you?
I'm on paragraph 42, page 238.
Yes.
Where it says the jury, there was a distinction that was used by the court, and this distinction informs our consideration.
Of both kidnapping related contentions? But if the jury is not even being asked to consider asportation, why are they finding that the evidence was sufficient to establish it? So if that were a separate thing that the prosecution had to prove, why is the court making that observation? I don't know. Is that relevant? Is that relevant that the jury wasn't asked to consider asportation?
I don't think it's relevant to the question before your Honor. I mean, look, like I said, the posture of IOB is certainly different from the posture here.
Yeah, all of these cases are, really. I mean, all right, give me 5 minutes. We'll be in recess for 5 minutes, and then I have an answer.
All right.
Everybody can sit down. First of all, I want to confirm, I understand that from the argument that everybody agrees that we should be interpreting this the way Illinois courts would interpret it. Correct so far?
Yes, Your Honor.
I mean, Mr. Scholar, you're the one who gave me the Illinois jury instruction. So if that's not correct, I don't know why I was reading all these state court cases.
Well, what I would say is that first, if
Sorry to put you on the spot with my law question there.
I would say that under Hayward, that it should be distinct, and if it should not be just given to them as just one general verdict. But if the court is going to instruct according to Illinois state, it should. The Illinois court to do it, I don't know if that clarifies it or if it makes a mess.
It makes it a mess, actually, because I don't think Hayward stands for that proposition. Hayward is dealing with the Supreme Court's decision in Davis, which is something entirely different, I think. So as far as I understand it, here's the state of the law in Illinois. The only question is whether or not, because we're asking the jury to determine a pattern, racketeering act, which is a separate question. They're not a jury sitting in Illinois.
Is Rhoda there?
What happened?
Should I read it or is she back?
It might make more sense to, and it might be safer to do it having them return, be anonymous in those two things. That being said, I'm just throwing this out there. That with respect to murder, the Supreme Court of Illinois in 2009 in People Against Smith, which is reported as 223 Illinois 2D1, says that the statute describes 3 types of murder, but first degree murder, it is a single offense. And the court says that because first degree murder is a single offense, it is constitutionally permissible for jurors to return a general verdict of guilty, even if there's no jury unanimity, never say that word, with regard to the means by which the murder was committed.
So it seems clear that when you're talking about a statute that is one crime as kidnapping is, that's the position of the Illinois Supreme Court. The separate question, which I'm going to give you 2 minutes to consider, is whether, because we're in a federal court talking about a jury returning a verdict on a predicate act, as to whether they have to be unanimous as to how the predicate act was committed. And then we have to rewrite that part of the jury charge a little bit if that's, I think all we have to do is add that, and I actually think it makes more sense.
Your Honor.
And again, I will express frustration. I should not have to be deciding this when the jury is deliberating. And because of that, and I blame both sides for it. So while I mostly blame the defense for not objecting, but this is not ideal when you have a jury who is waiting for an answer on it. So again, that's why I give out the charge early, so we can iron these things out before. So I'm not aware, but that doesn't mean they don't exist. A federal racketeering act, federal racketeering cases addressing this subject.
Nor am I, Your Honor.
Actually, Judge, not specifically this subject, but with respect to whether the jury could select 1 or 2 options in rendering a verdict, and whether that made it, I don't know, whether it made it a general verdict and whether it was appropriate. I think Hayward is the start of.
Well, I'm making a decision. I'm going to do it that they have to be unanimous on both. Just rewrite it, so I guess we can rewrite it. I want to move on from this, and I think that's the safer course. So I'll take it there are no other instructions in here like that. I don't think there are. In fact, I feel like you precluded on it. I've already charged the jury. But for this one, because they're asking about it, are there any others?
Your Honor, I guess I just want to understand what your ruling is, that you're going to require them to be unanimous.
I am, because I think it's safer. I think it's safer. It's not worth it. Let me quickly look through the charge to see what else is there. If there are others, I don't think there are, because the other ones are charged as separate racketeering acts like A and B.
That's correct.
I mean, the question for me is whether we are deciding this the way Illinois Supreme Court cases would, whether this is how an Illinois Supreme Court would decide the case, or whether there's a separate analysis because it's a racketeering act.
Your Honor, because it is state statute, I believe it's clear that the interpretation of state law, the state's interpretation of their own law applies here, and that this is absolutely a question of an Illinois law. Nor am I aware, frankly, of a federal case that would call for a different conclusion here. But I think that when a court is analysing the sufficiency of a state law-based racketeering act, it looks to state law.
Hold on for just 1 second. All right, I do want to be correct about this, and that's why I want to make sure that I'm giving them the right instruction. As I say, partially because it hasn't been asked of how until now. I'm not aware of a case where a court has addressed how to analyze a state law-based racketeering act. And as far as I understand it, I don't know that anybody else has one either. So I'm going to take another 5 minutes, unless you have a case that is on point. I don't think Hayward applies. Hayward is talking about a specific federal statute, and it's based on a specific Supreme Court ruling, and it doesn't apply in this instance. All right, I'm going to take 5 minutes again.
All rise.
Let's wait until the defendant comes back. Everybody can sit down. Okay, I've taken another look for additional cases in the area of racketeering and haven't found them. I will also say, since the charge was drafted and given to the jury with the input of all the parties, I'm not saying it's waived, but I think it's a little late to go tinkering with the charge I've already given them. But most importantly, I think that the correct way to look at this is, since we're charging a state crime, is to look at it the way the state interprets the case. And in my view, under Ioby and Smith, the statute is a single offense, and that's how Illinois interprets it. And that's how I think it should be interpreted for purpose of this charge. So I'm not changing the part of the charge. I am, however, going to do what was the simpler thing, which was giving them that and or language, which now I just have. Can you print that again for me, Donna? All right. So after we print that out, we will get the jurors.
The latest one you sent me, that's the one you sent me? Which one am I printing, Judge?
It was Judge, what is that?
Vitaliano's. Your Honor, I believe you may also edit Judge Vitaliano's.
I did. I'll just have to remember how I did it. Just to be clear, I'm just looking through the transcripts here. One or more count of the indictment may accuse the defendant of violating the statute in more than one way. The indictment may allege that the defendant violated the statute by various acts which are in the indictment, joined by the word and while the statute and the elements of the offense are stated using the word or. In these instances, it is, of course, I can't read. I don't know what I said though. Can we just print the page out for this transcript? Then you email it to Miss Green?
I believe we emailed Judge Vitaliano's instruction. Do you want us to just email again?
Might as well.
Your Honor, if I remember correctly, I believe your concern was that it was reading passively. So Your Honor stated,
I was just reading what I had said, that you all had said was okay. But I think I trailed off at the end, so I didn't finish it. And I just want to make sure, since we spent all this time on it, I may as well get it right.
Judge, I'm sorry. Can I say something or should I wait?
Are you afraid you're going to confuse me?
No, we just wanted to preserve our objection.
It's preserved.
And I just wanted to argue one last time that since the Racketeering Act hinges on the state's charge, that I guess what I'm arguing is that the appropriate lens, what I'm arguing is that since the racketeering charge hinges on the state charge, the proper, because someone finished reading, I've lost it.
Right. The proper or the appropriate way to look at it would be to look at it as a federal charge and under the line of cases, Deschamps, which is 570 US 254, which was decided in 2013. Howard, which was decided by 11th Circuit in 2014, and now Hayward, that the arc of these cases are indicating that giving the jury a general verdict or decision and having them render a general verdict is not appropriate.
But that's not, I mean, the one from Alabama, they're not quarreling with that burglary means. They're just saying that for purposes of being sentenced as for purposes of sentencing. None of those have anything to do with the jury charge.
Yet.
Did you say yet?
Yet.
Yeah. Oh. I'm arguing that as I read those cases, that the arc of those cases are discussing how a jury is providing the charges. And when they're provided a general verdict or rendered a general verdict, that's not the appropriate function of the jury. If they're court.
Okay, well, okay. I'm going to interrupt you because that's not what they're saying at all. They're not saying, for example, that the Alabama burglary statute is unconstitutional. They're simply saying that for purposes, if I'm remembering correctly, of determining whether the defendant committed a violent offense for the purposes of sentencing, they look to the language of the statute. And this is whether it's, I can't remember. I can never remember which is which, whether it's inclusive or the
categorical
or non-categorical. And that's what that's talking about. It's not talk about a judge charging a jury in a racketeering case. That's based on state law.
Understood, Judge. But that's how it started and we ended up with the Hayward.
But only because of 924 paren C.
Yes, 924C. But still racketeering, that was charged in those cases.
But they were only talking about sentencing. I think they found the conviction. I think they affirmed the conviction. They just said he couldn't be sentenced that way. I'm pretty certain that's right.
I guess that's the problem in those cases, was that the Supreme Court then struck down one of ways in which this crime could be committed. And that's created an illegal verdict, basically.
No, it said nothing about the verdict. It was talking about whether in any way is not the same situation. You know that you know what? It might be the same situation, and then the Second Circuit would tell me, and you would have been right, and you can write me a letter. Oh, Lord. So here's what the language is going to be. One or more counts of the indictment may accuse the defendant of violating the same statute in more than one way. In other words, the indictment may allege that the defendant violated the statute by various acts in the indictment uses the words and, while the statute in the elements of the offense uses the word or. Is that what I said before?
I believe so, Your Honor.
In these instances, it is sufficient for a finding of guilt if the evidence established beyond a reasonable doubt that the violation of the statute by any one of the acts charged. All right?
And Your Honor, do you want to also make clear that one or more counts of the indictment, including racketeering, Act 3 of Count 1, since that's the charge that they for a question about?
Racketeering Act 3, Count 1?
Of Count 1.
Your Honor, we would object to anything superficially in response to the note. We would just ask the court to respond specifically to the note and nothing superfluous. Superfluous.
I think that's what I'm doing. Taking out some extra language. That's what I'm doing. All right. Okay, I think we can get the jury.
And Your Honor, what the government proposes is that in light of the note and specifically addressing the note, that we can make clear to the judge that in this particular case, that and does not mean or with respect to the and in 5-10-1.
Then if you're doing that, Your Honor, then we don't need anything else. If you're just going to give the specific language, because if that's what they're asking for, if the government is saying that that's what they're asking for, then simply.
You want me to say and means or in the indictment because this is better. I'm going to do it this way because there's ands all over the place. If they start substituting or where it belongs, it's not going to make any sense. Let's get the jury, please. Yeah, let's get the jury.
All right.
You may be seated. Oh, I'm sorry. Okay.
You may be seated.
Okay. Ladies and gentlemen, we received your note this morning, and I'm just going to read it into the record. We, the jury, need clarification of Illinois Criminal Code, Section 5-10-1. It is stated two different ways. A difference between and or is and then the second request was the testimony for Nicholas Williams and Tom Arnold, which I think you have correct.
Yes.
So with respect to your first question on the and or issue, one or more counts of the indictment, including Racketeering Act 3, under count 1, may accuse the defendant of violating the same statute in more than one way. The indictment may allege that the defendant violated the statute by various acts, which are joined in the indictment by the word and. while the statute and the elements of the offense are stated using the word or. In these instances, it is enough for a finding of guilt if the evidence established beyond a reasonable doubt the violation of the statute by any one of the acts charged. A shorter way of saying this is that in the indictment and in this situation means or. Okay? All right? I hope that answers your question. We can take the jury out.
All rise. You may be seated.
All right. So we will be, I don't believe there's anything else for us to do right now. So we'll be in recess until you hear from us again. By the way, that note is court exhibit number 5.
Your Honor, we'll be from 1 to 2. Will that be a down period for lunch, or do you want us to be available?
If you don't mind being available, once again, I have a couple of other cases that I'm doing over the lunch hour. But I mean, don't go up to Arthur Avenue or anything for lunch.
Can we talk about one thing off the record?
Sure.
All rise.
Everyone can have a seat. All right, folks. We received a note from the jury which reads as follows. From foreman juror honor. Subject, read verdict. We, the jury, have finally reached a verdict, and it's signed by juror number 1. This will be court exhibit number 6. Anything before we bring out the jurors?
Yes, Your Honor. That damn fast, they came back with a verdict? Oh, I'm sorry, that's the wrong line. I'm sorry. Nothing
Oh.
from us, Your Honor.
No, Your Honor.
And just so you know, we'll have the alternates in here too. They'll sit in their place in the back. Obviously, they'll be brought in separately, and we'll have the regular jurors in their regular spots as well. All right, let's get the jury. Sorry, the alternates will come in first and sit in the back. Obviously, they've been separated the whole time.
All rise. You may be seated.
Okay, ladies and gentlemen, I have received your note indicating that you have reached a verdict. Will the foreperson please rise? All right. As to count 1, racketeering, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
As to racketeering act number 1, bribery, proved or not proved?
That shit wasn't proven, Your Honor. Proved, Your Honor.
As to racketeering act 2, sexual exploitation of a child, Stephanie, do you find proved or not proved?
Proved, Your Honor.
As to racketeering not proved?
No, not proved, Your Honor.
Racketeering Act 4, Mann Act, violations, Sonia. What is your verdict with respect to Racketeering Act 4, paren A, transportation, proved or not proved?
None of them was proved, Your Honor. Oh, I'm sorry. Not proved, Your Honor.
What is your verdict with respect to Racketeering Act 4B, coercion or enticement, proved or not proved?
Not proved, Your Honor.
Racketeering Act 5, the Mann Act, violation, geranda. What is your verdict? Proved or not proved?
Proved, Your Honor.
With respect to Racketeering Act,
Somebody want to finish?
With respect to Racketeering Act 7, sexual exploitation of a child, Johonda, is your verdict proved or not proved?
Oh, who was up on 6? Go up to the one before.
15.
Proved,
15.
you're on
Your Honor.
11.
Line
You're on
9.
11. You're on 11.
9 line? Oh, it's on 11?
Mhm.
I think, okay.
You're on 11. Mhm.
Okay.
Fine. Yeah.
Proved, Your Honor.
With respect to Racketeering Act 7, sexual exploitation of a child, geranda, is your verdict proved or not proved?
Proved, Your Honor.
Racketeering Act 8, Mann Act, violation, Jane. What is your verdict with respect to Racketeering Act 8, Paren A, transportation, proved or not proved?
Proved, Your Honor.
What is your verdict with respect to Racketeering Act 8B, coercion or enticement, proved or not proved?
Proved, Your Honor.
Racketeering Act 9, Mann Act, Jane. What is your verdict with respect to Racketeering Act 9A, transportation, proved or not proved?
Proved, Your Honor.
What is your verdict with respect to Racketeering Act 9B, coercion or enticement, proved or not proved?
Proved, Your Honor.
What is your verdict with respect Racketeering Act 9C, coercion or enticement of a minor, proved or not proved?
Proved, Your Honor.
What is your verdict with respect to Racketeering Act 9D, transportation of a minor, proved or not proved?
Proved, Your Honor.
Racketeering Act 10, sexual exploitation of a child, Jane. What is your verdict? Proved or not proved?
Proved, Your Honor.
Racketeering Act 11, forced labor, Jane. What is your verdict? Proved or not proved?
Proved, Your Honor.
Racketeering Act 12, Mann Act, violations, faith. What is your verdict with respect to Racketeering Act 12A, transportation, proved or not proved?
Proved, Your Honor.
What is your verdict with respect to Racketeering Act 12B, coercion or enticement, proved or not proved?
Proved, Your Honor.
Please indicate which of the statutes the sexual activity violated. Reckless endangerment in violation, New York Penal Law 120.20, knowing exposure of an infectious venereal disease, violation of New York Public Health Law, Section 2307, or both.
Violation of HIPAA, Your Honor. Both, Your Honor.
Racketeering Act 13, forced labor, faith. Is your verdict proved or not proved?
Proved, Your Honor.
Racketeering Act 14, Mann Act, faith. What is your verdict with respect to Racketeering Act 14A, proved or not proved?
Proved, Your Honor.
What is your verdict with respect to Racketeering Act 4B, proved or not proved?
Proved, Your Honor.
Please indicate which of the statutes the sexual activity violated. Reckless endangerment in violation of New York Penal Law, Section 120.20, knowing exposure of an infectious venereal disease, violation of New York Public Health Law, Section 2307, or both?
Both, Your Honor.
As to count 2, Mann Act, transportation, Jane, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
As to count 3, Mann Act, coercion and enticement, Jane, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
As to count 4, Mann Act, coercion of a minor, Jane, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
As to count 5, Mann Act, transportation of a minor, Jane, how do you find the defendant? Guilty or not guilty?
We find the parents guilty, Your Honor. Oh, I'm sorry, guilty, Your Honor.
As to count 6, Mann Act, transportation, Faith, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
Please indicate which of the statutes the sexual activity violated. Reckless endangerment in violation of New York Penal Law, Section 120.20, knowing exposure of infectious venereal disease, violation of New York Public Health Law, 2307, or both?
Both, Your Honor.
As to count 7, I'm sorry, we just want to make sure everyone can hear you. So we're going to give you a microphone, okay?
Yes, Your Honor.
All right, as to count 7, Mann Act, coercion and enticement, Faith, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
Please indicate which of the statute the sexual activity violated. Reckless endangerment in violation of New York Penal Law, Section 120.20, knowing exposure of infectious conveniently disease in violation of New York Public Health Law, Section 2307, or both?
Both, Your Honor.
As to count 8, Mann Act, transportation, Faith, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
Please indicate which of the statutes the sexual activity violated. Reckless endangerment in violation of New York Penal Law, Section 120.20, knowing exposure of infectious venereal disease in violation of New York Public Health Law, Section 2307, or both?
Both, Your Honor.
As to count 9, Mann Act, coercion and enticement, Faith, how do you find the defendant? Guilty or not guilty?
Guilty, Your Honor.
Please indicate which of the statutes the sexual activity violated. Reckless endangerment, knowing exposure of infectious venereal disease, or both?
Both, Your Honor.
You may be seated.
Thank you.
Would either side like the jury polled?
No,
Geddes?
Your Honor.
Yes, Your Honor.
All right. Ladies and gentlemen of the jury, you have said that you found the defendant, you have said that you found the defendant guilty of counts 1 through 9. Count 1, racketeering. Count 2, Mann Act, transportation, Jane. Count 3, Mann Act, coercion and enticement, Jane. Count 4, Mann Act, coercion of a minor, Jane. Count 5, Mann Act, transportation of a minor, Jane. Count 6, Mann Act, transportation, Faith. Count 7, Mann Act, coercion and enticement, Faith. Count 8, Mann Act, transportation, Faith. And count 9, Mann Act, coercion and enticement, Faith. Jury number 1, is that your verdict?
Yes, Judge.
Jury number 2, is that your verdict?
Yes, Judge.
Jury number 3, is that your verdict?
Yes, Your Honor.
Juror number 4, is that your verdict?
See, Your Honor.
Jury number 5, is that your verdict?
Yes, Your Honor.
Jury number 6, is that your verdict?
Yes, Your Honor.
Juror number 7, is that your verdict?
See, yes, Your Honor.
Jury number 8, is that your verdict?
Yes.
Juror number 9, is that your verdict?
Yes, Your Honor.
Juror number 10, is that your verdict?
Yes, Your Honor.
Juror number 11, is that your verdict?
Yes, Your Honor.
Juror number 12, is that your verdict?
Yes, Your Honor.
The jury's verdict is recorded. Ladies and gentlemen of the jury, this is your jury service. You have answered the call to serve as citizens, and you've paid such careful attention throughout the course of the trial. Been here on time every day, and it's been clear to me that you've listened carefully. Whenever a jury carefully considers the evidence and renders a verdict, you serve your community and the country. As I've told you, when you were selected as jurors, we could not function without citizens who are willing to give up their time, as you have done in this case. And so I thank you for your service. If you wouldn't mind waiting in your jury room, I'd like to thank each of you personally and give you a check.
Yeah.
All right? Thank you.
All rise.
All right. Everybody can have a seat. Let me hear from the defense. Anything that you want? Do you want to reserve on your motions, or do you want to make them now?
Judge, we'd like to Judge, we would ask to reserve the motions and would ask to be able to file those at least 30 days from now.
All right. Government?
No objection.
All right. So let's just see if we can pick a date now.
October 27th.
So October the 27th for the defense motions. Is that all right?
Can we go to November 1st, Judge?
Sure. November the 1st. How much time does the government need to respond?
3 weeks.
Where does that take us, Donna?
The 22nd.
November the 22nd? And maybe a little, I don't know when Thanksgiving is this year, but a little extra time to respond?
December 6th.
Can it?
Hold on. Yes.
December the 6th?
Thank you, Judge.
Hold on just 1 second.
May 4th at 10 a.m.
All right. We're setting a sentence date of May 4th at 10 a.m. Anything else?
No, Your Honor. Nothing from the defense.
I do want to commend both sides for professional enable presentation of the evidence. And for the defense, with that defense counsel provided to Mr. Kelly. All right. Thank you so much.
Your Honor, may I get the time on the 4th again?
10 a.m.
Thank you.
May I see the parties at the side for a second? No need for the court reporter. All right, folks. Unless there's anything else, we're in recess. And that's that.
Yeah, well done. We did it.
Woo.
Well done, Rhoda. You read so well.
Man, oh man.
Everyone did.
Atrocious.
Yep.
Amazing.
You see all the confusion and trying to figure out what this mean and what that mean?
But it is so crazy that you see how long it took the attorneys and the judge to come up with the proper wording.
Mhm.
And then as soon as she gave it to him, it was like, okay, we got a verdict.
Exactly. So quick. Crazy.
Mhm. They came with it quick. It didn't
They came
matter
back
what
so
they
quick,
were
I'm like-
saying, wasting all that time with the ands or this or that. Their minds was already made up.
It was
It
already
didn't
made
matter.
up.
It was
It
already
didn't
made up.
matter. Yeah. So why send the questions back like they was really deliberating when they already had the answer already in mind?
They were fronting.
Just
They
like
was
talking,
just
to children,
fronting.
honestly.
Oh,
Oh wow.
All right, guys, I'm gonna end this and thank you
all right.
everybody for reading. I'm
Oh,
very
you're welcome.
You're
I'm headed to the grocery store.
all right. So what I'm gonna do, I'm gonna go over to Spitting Fire because I see she's going in.
Oh,
Okay.
okay.
All right.
All
Bye.
right, guys. See y'all
Bye.
later. Thank you, everybody.
Okay. All right. You're welcome. Okay. Bye-bye.
Bye.